All right. And realizing that some of the issues are so cross-cutting that once a particular appellant or respondent has addressed that issue, it may not require so much time to say the same thing.
Yes, that's true. For instance, like for us, we want the basic structure, thematic area, which if we have exhausted, then we need not have it repeated. Similarly, if Tuma here has addressed the issue of the quorum of the IBC, we need not address it. And I believe in the course of the oral submissions, the court will guide us accordingly, so that we don't veer off and repeat what another colleague has said.
All right. So now, thank you.
I want you to note that in the submissions, you are restricting us to 30 pages. If you are not restricting us on the written submissions, then I would understand why we should get 1 hour. Unfortunately, looking at the judgment, there were nearly 23 declarations made by that court affecting our clients, 2 clients we represent, all those 23 declarations. And you are minimizing the length of the submissions. And there's the other very important issue that this matter, it's not just a matter for this court. The hearing of this petition will be done in the full glare of the public. People would want to understand why this court will make a particular decision. I will plead with you that this is a very unique case, it's a very special case, looking at the circumstances. And it is about our Constitution. So I would plead with the court that if in an election petition, presidential, which is narrowed to the question of declaration of the seat following a presidential election, and you are given 3 hours for each party, and I've been in those petitions. In this particular appeal, or appeals, there were 9 petitions in the High Court, each seeking very unique declarations or decisions. And I don't think on behalf of my client or clients that an hour with 30 pages submissions would suffice doing justice to this case. And the public would also want to understand.
What would be your suggestion there for senior counsel?
I would go by the original suggestion that was made by senior counsel, Mr. Oraro, that you give us 4 days. And 4 days for this court to give to this very unique case would not be asking too much of your lordships. That out of those 4 days, you give 2 days to the appellants. And you know, in the High Court, we had less time because each respondent had a petition before the High Court. We had to respond to all those petitions. And then the other 2 days you give to the respondents. That is how it is done in the presidential petitions. And it works very well. Between us, we can then share those 2 days and make sure that we make out our respective plans within those 2 days. I would really plead on this.
And what about if there are more respondents than the appellants, as it is actually here? So far we have 4 appellants, and I think a number of, is it 10 or 15 respondents? Should it still be 2-2? Or because they are responding to more or less the same issues, you think the 2 days will still be sufficient? Senior counsel? No, just hold on.
Yes, because we are the ones prosecuting the appeals. They will be also responding to those appeals. So if they are given that, and normally this court normally would try to determine who are supporting the appeal or who is opposing. And you try to minimize their time if you're just opposing, and probably your participation in the High Court was just on one issue. there was a petitioner whose issue really was about the conduct of the president in respect of Chapter 6. It was basically one issue. And I think to that extent, we can be able to organize ourselves. For example, amongst the appellants, the IBC has their role is not going to be as extensive as, for example, the Attorney General and ourselves. So between ourselves, we can organize ourselves in such a way that Mr. Raro probably can take 3 hours, and I probably can take 2 hours, depending on how we organize ourselves.
All right. As senior counsel, before you take your seat, you know, in these COVID times, we are limiting the amount of time we are spending sitting like this. It is not comfortable wearing these things for 2, 3, 4, 6 hours. What about if we enlarged the length of your submissions and reduce on the time so that there's so much that is covered in writing? You are able to say even stretch it to like 50 pages, and then you have like an hour and a half to basically highlight your well-written submissions, which are more exhaustive. I truly hear what you are saying. We need to do justice to this matter. But I think it is going to be very uncomfortable for all of us, whether we are sitting in this place or in a bigger space, as I will be saying in a little while, to spend 8 hours or 6 hours in a day putting on masks, being confined in a tent or in a courtroom like this. The presidential election petition and other matters have been done in what I may call COVID-free days, when, you know, the court can sit even up to from morning till evening at night. We really don't want to be in this kind of setup for too long a time. Yes, Mr. Kanjama, we'll come to you.
My Lord, if I may just refer to what Lady Justice Nabuye mentioned.
Yes.
And to say that I have been with senior counsel Rengo in the Supreme Court on an election appeal, not an original election matter, gubernatorial. The Supreme Court would typically give 1 hour maximum for submissions, even with very voluminous record of appeal and submissions filed by the parties. My Lord, I would like to add that because this is a constitutional matter, it's a matter in rem, interests of parties cannot be easily sliced and diced and categorized as either supporting or opposing. There is a lot of jurisprudence in the judgment, so that the idea of giving a block of time to appellants and a block of time to respondents does not respond appropriately to the fact that each appellant and respondent may have different views on the various matters. Thirdly, because of the rules of this court, even if a party in the High Court was focused on 1 or 2 points of argument, once the judgment has been issued, a party in the Court of Appeal, by filing a notice of cross-appeal or grounds of affirmation, will be interacting with the entire judgment. And each party may have different views. So that the appropriate direction should be focused on each party, whether appellant or respondent, receiving roughly proportionate time, because they each need to deal with the various issues according to the instructions of their respective clients. And I do support the suggestion by LSK President Nelson Harvey that each party should not have more than 1 hour. 1 hour roughly, they will determine how to use that time. That is all.
Hello, may I make a suggestion?
Yes.
I think I agree more with my President, Mr. Nelson Harvey, because the additional half hour that we get in the main arguments, the respondents will clearly back in reply, so that in the interest of quality of us, each party ends up having 1.5 hours. That's my suggestion.
All right, thank you. Any other view before we leave that issue? Dr. Tiangolu, then, oh, sorry, okay, you're on your feet. It's okay. Okay.
He says I can go ahead, my Lord.
Yes.
My Lord, while still on the issue of time, I think for me the considerations are as follows. Number one, this is arguably the most important litigation of our lifetimes. I've had comparisons with the presidential election petition, but if I had my senior Jimmy Orengo, this is about the constitution of Kenya, and it's about the posterity of Kenya. So in my view, although there is a genuine case for limiting the time, we shouldn't box ourselves into a corner that says it is 1 hour, it is 2 hours, as though what is at stake is the time and not the future of Kenya. So if the petitioners, or rather the appellants, want 3 hours, in my view, subject to an equality of arms, it is not too much to ask, in my view, for a case that is arguably the most important case of our lifetimes. The only thing I would suggest, my Lord, I think that the reason we're having all this back and forth is we have boxed ourselves into the 3 or 4 days that the court gave as an indication. And I would urge the court to consider, is it possible to have, say, the 3 or 4 days in 1 week for the appellants and 3 or 4 days in the next week for the respondents, and then a direction that says those 3 or 4 days, the appellants must go and conference amongst themselves and know how to share the time, and in the other week, the 3 or 4 days, the respondents will conference amongst themselves and communicate to the court how they plan to share that time. I know, of course, this court is very stretched in terms of its human resources, but then again, it must be recognized that this is arguably the most important case that will ever be argued in our courts in our lifetime. As regards the physical space, again, I think it's a matter where we can be flexible. The state has no shortage of resources. I was just whispering to my senior, Paul Mwang here. We have even a facility here at KICC. We can set up a temporary court there, gazette it specifically for this, and then we can assuage some of these concerns about,
I will address that in a little while. Just limit yourself to the issue of the time, then I'll come to that.
So, my Lord, I was saying 3 or 4 hours that they request, they're just 4 appellants. To me, it's reasonable, given the magnitude of what is at stake. It's about how Kenya is governed in the long term. The only right there is, if you give them the 3 hours, then be mindful to give us, as the respondents, an equal amount of time that is fair. Remembering we'll be responding to all of them, not necessarily to one of them, even if the cases are merged.
All right.
Can I say something, Madam?
Yes, Dr. Meno?
Yeah. I do appreciate what you're going to say about wearing masks. It's very uncomfortable. I find it very uncomfortable. I would suggest that the best way out of this is to increase the number of pages that each party can submit to 20 pages or 30 pages, you could probably increase it even to 40, and then you are able to shorten the time you are directly in the court. Perhaps I may add, my Lord, it's not only Kenya that's interested in this judgment. In fact, from what I've heard and seen and so on, the international community is very much interested in this case. They would like to see what you want to say and so on. So it's fair that each party is given enough time to be able to address the exhaustively. And the only way we can get out of this problem with the COVID around 13 all of us is to allow us to put in more pages, probably 40 pages or even 50 pages, and then we can shorten the number of hours or the number of things to be addressed.
All right, thank you very much. We are going to, we will take any into consideration as we give directions shortly. Talking about the issue of how the hearing is to be conducted and the space. One, there will be a bench of 7 judges to hear the appeal. And so you can see that we cannot fit 7 of us here and keep the COVID-19 protocols. So we need a bigger space. And arrangements have been made to pitch a tent within the court premises outside the Chief Justice's gardens with the permission of the Chief Justice. If we agree that we are going to do this matter in that way where there is physical appearance, there will be adequate space for counsel and for judges. But we can also agree that we conduct a hearing virtually. I know from the correspondence that I've seen from most of you, and we know it, there are challenges when it comes to virtual hearings. Connectivity, sometimes Wi-Fi may not be working. We are not able to hear one another well. So I want to quickly hear your views on that before the court makes a final decision. Of course, today we are doing it in a dual manner where we are here, others in a seated courtroom next to this courtroom, and there are many Kenyans who are following it from the comfort of their rooms because we have sent out a link. May I quickly hear your views regarding the mode of hearing that we should have? Senior Counsel, Mr. Oraro.
On the part of AG, we suggest that we have a physical hearing, and with the permission of the Chief Justice, we can proceed with the idea of having that hearing
on our part, physical hearing, and I think on the part of the premises proposed, we're quite happy with that space.
Okay.
We agree with what the senior counsels have said. Physical, in-person hearing.
In-person hearing.
Virtual hearing cannot.
Sorry? Sorry?
Virtual hearings are not hearings for
Okay.
My Lord, we are happy to associate ourselves with the sentiments of our colleagues.
Okay, in-person hearing, yes. Yeah.
And we are equally happy with the directions as part of the request we had made to our letter. So we are happy with the physical.
Thank you. In-person, okay. Any other alternative view?
My lords, my ladies, I like the approach you've adopted today.
Yes.
I think you may find that because the hearing is going to take a substantial period of time, some of the parties may want to have the option, especially when they are not scheduled to address the courts, to be present virtually. So I propose a hybrid hearing where the parties will be addressing the courts can preferably be present physically, and those who, other parties who want to be present physically, but the parties also be given the option.
Yes.
Especially because the hearing will take a long period of time.
Yes.
To occasionally appear virtually. So the way we have set up today, we set up that way for the main hearing. That's my proposal.
All right, thank you. Any other suggestion?
Yes, my Lord, I think we should go throughout the week. I just suggesting the only thing I would should take care of the bandwidth, because you don't need to be a prophet to know that when that time comes, there will be very many people logging in onto the virtual platform. And from the experience with the airport, there was a lot of struggle because of the traffic. So I think the administrative officers of the court should have done it.
Thank you for that suggestion. All right, I think that is sorted, and thank you very much. We have said that about the number of...
Can I ask a question to the council? How would you feel if some of the 7 judges decided to hear the matter virtually? Because of the same concerns.